Good morning, everyone, once again, and thank you very much for your patience and understanding. Thank God. The difficulties have been resolved successfully. Today we're going to discuss the issues related to the possibilities of using mediation and the definition of mediation in family relations and in protecting of the interests of and rights of children. This is a very important topic to discuss, and I'm very grateful for the panelists who agreed to come over here to participate in our session. And I would like to introduce, first of all, my co-moderator, Mr. Veniamin Kaganov. He is Deputy Minister of Education and Science of Russian Federation. And we're going to speak about it later, about the ministry's contribution in protecting and safeguarding the interests and rights of children, and we'll speak about our cooperation with this institution. Our guest, Mr. Christoph Bernasconi, Secretary General of the Hague Conference on International Private Law. We have been cooperating with the Hague Conference for a number of years now, and it is the Hague Conference that has made a big contribution and focused its attention in regulating mediation in transborder family disputes, in the issues related to children's kidnapping. And you probably know that starting with 2011, Russia has joined the Hague Conference of 1980, and last year we joined the conventions of 1996, and at the end of April, beginning of May, a law has been adopted that gives us the full legitimate right to implement the provisions of the conference. We have the legal framework in place to fully implement the convention. So far, we have no official agreement signed with all the signatories, but I think that Mr. Bernasconi is going to comment on that in his intervention. But for us now, it's critically important to have these agreements and make them fully active. Another panelist is Mr. Jean Ayoub, Secretary General of the International Social Service Network, and it is very important as well to have him as one of the panelists at this meeting, and issues related to protection of interests and rights of children and protecting children from ill treatment or resulting from transborder disputes and conflicts is one of very difficult issues, and the International Social Service Network also focuses on mediation, development and promotion, and mediation is universal, is one of the universal and means of finding ways out of conflicts and disputes, so that the quality of everyday life could be sustained and maintained at a good level. Hence, all international organizations and institutions pay a lot of attention to mediation. And Mr. Pavel Astachov, Children's Rights Commissioner for the President of the Russian Federation, the person who has been doing everything possible since this institution was established in the Russian Federation to help the Russian children feel the support and care of the state, to feel that they do have protection and remedy in the face of the society and the state itself. We are about to embark upon our session now, and Mr. Kaganov, maybe I will ask you to say a few words. Good afternoon, dear colleagues. Many thanks for to all those who participate in this legal forum we held in this wonderful city. Yesterday I was in Krasnodar, where it is plus 29 Celsius, and now it is plus 8 only here in St. Petersburg. However, it feels always warm and nice in St. Petersburg because the high level of culture which has been historically intrinsic to the city and the warmth of the residents' hearts will promote fruitful exchanges and networking. All the security measures taken to organize this forum unprecedentedly high, and even for me it was not an easy thing to penetrate through the security stand. However, there was a technical nuisance and it was resolved, and I apologize for delay. We have come here to discuss the topic that is crucially important. Mediation and the technology of mediation has permeated the whole. I would have liked to say that this system permeated the education and science in Russia. However, it is too early to say so. And together with the basic institution, which is represented by my esteemed co-moderator, we need to do a lot in order to fully implement mediation mechanisms that could apply in various institutions, educational institutions, the system of education, and society in general. It has been an ongoing and lasting demand for many years, and it will still very important to have it. Using my capacity as co-moderator, I would like to use this opportunity to say a few words about the issues that of our concern in this and related areas. And I also would like to inform the audience about the situation as is in the ministry that I represent. To effectively resolve disputes for the parents who live on the territory of different states, the Hague Conference on International Private Law have developed many tools, including the Convention of 1980 on the kidnapping of children. The signatories of these conventions include 90 states. It was signed by Russia 3 years ago already and came into effect on the territory of the Russian Federation on the 1st of October 2011. The central authority in Russia has been responsible for the implementation of this convention, has been appointed our Ministry of Education and Science of the Russian Federation, and is applicable when one of the parents, without the permission of the other, takes the child away from the one permanent state residence or permanently for some time, agreed time, and does not bring back the kid, so just illegal retention. And then the parent has the right to appeal to the central authority if Russia is involved, and to make a query to the territory of the state from which the child was removed. So we have 70 queries about bringing back the minors. About 50% of them are queries initiated by Russian citizens who request bringing back their children from France, Armenia, FRG, Czech Republic, and Ukraine, and others. As of the beginning of last month, the convention came into effect between the Russian Federation and other 34 signatories of this conference. 12 out of them are states, member states of the EU. It is very important for us that other states recognize Russia as a new member of the convention, but we also need to do a lot on the territory of the Russian Federation to back it up with the local legislation that will support the implementation of the convention. I'm pleased to inform that on the 17th of May, a federal law was approved in the Russian Federation on amending singular legal acts of the Russian Federation tied up to the signing of the convention, the Hague Convention. And this federal law creates necessary legal tools to provide for the implementation of Russia's obligations under this convention. It has been a very important step to make, and just finalizing the creation of the legal framework will enable us to efficiently create a set of tools and instruments to provide for this. So we also improve the federal laws on prosecution and just others, so which includes the instruments that we, as the central authority responsible for the implementation of the convention, can provide for the implementation of Russian obligations in terms of the detention of children. So we can provide specific examples when a child was taken away from the Russian Federation to Armenia. That was made by the grandmother with their assent, but later the mother, who resides in Armenia, rejected bringing him back, and the child was kept in Armenia with the grandmother. So since it was active marriage, so the rights of the two parents were equal. So we tried to work with the father because the conflict was escalating. We worked with the representatives of the mother, and just both claimed that they were ready to resolve this conflict in an amicable way, but it turned out that it was not so in reality. As a result of our effort and cooperation of our Armenian counterparts, we managed to resolve the conflict in the interests of the kid and the family, and this specific example supports the fact that cooperation and interaction between the relevant institutions is very important as gaining and sharing the practice and experience in these conflicts. However, practice shows that the state authorities seldom successfully resolve such conflicts, and during the negotiation and mediation process we need to involve professional expertise, and hence in 2013 our ministry created the Federal Institute of Mediation that helps to integrate mediation in the routine of the children's rights commissioners in the entities of the Russian Federation. So this institute is the sole state-based institute in the Russian Federation that is responsible to establishing and implementing the state policy on the children's mediation, and implementing programs in just children's guardianship and protecting the interests and rights of children. We think the institution of mediation will be very helpful. Today's discussion, I hope, will be very useful in identifying the issues and problems, as well as bring together issues related to experience exchange, and basing on the international experience and positive progress that has been achieved in this country, we could design and develop an effective mediation system targeted at protecting the interests of the participants of the educational process and interests and rights of children and their families. So it's a lot I expect from this conversation. Wow.
Thank you very much. If I may, I'd like to give the floor over to Mr. Bernasconi, Secretary General of the Hague Conference on Private International Law.
Minister, dobro jutro. It's a real pleasure to be here today, this morning, and I would first of all take this opportunity to express my sincere appreciation to the organizers for having put together yet another edition of the impressive forum, for giving us the opportunity to participate again at this year's forum, and in particular in this panel, which I understand has become a tradition, a very valuable tradition of this forum. I take it that most of you know the Hague Conference on Private International Law as the World Organization for Legal Cooperation in Civil and Commercial Matters. The organization that adopts these famous Hague Conventions that deal with cross-border issues in family law matters, child protection matters, but also in transnational civil procedural matters, in commercial matters, in financial matters. So we are this global organization that tries to solve private international law matters through these Hague Conventions. The organization today has 76 members, including the Russian Federation. The conference has 38 conventions in total, including the Child Abduction Convention, but my point here being is that the Child Abduction Convention is one out of several other conventions that the conference has adopted. And may I take this opportunity to say how pleased we were to see the new implementing legislation that the Russian Federation has recently adopted for the effective operation of the Child Abduction Convention. Personally, I was in particular pleased to see that you have opted for the concentration of jurisdiction, which we believe is a very important means to facilitate the effective operation of the convention. There is also a total of 144 states that are nowadays connected with the work of the Hague Conference, because not all states are members of the organization, but they are party to at least one of our conventions. So the global stage for the Hague Conference is clearly set and known, I take it. What most of you probably don't know is that in the more recent years, the Hague Conference has become more and more involved in the field of mediation, particularly mediation in international family disputes involving children. One reason for this is that the modern Hague Family Law Conventions encourage and indeed facilitate the amicable solution of international family disputes. Let me give you a few examples. The 1980 Hague Child Abduction Convention requires central authorities of contracting states, now 92 contracting states, to take all appropriate measures, quote, to bring about an amicable resolution of the issues, unquote. The 1996 Hague Child Protection Convention, now 40 contracting states, including the Russian Federation, calls on central authorities, quote, to facilitate by mediation, conciliation, or similar means, agreed solutions for the protection of the person or the property of the child. And the 2007 Hague Child Support Convention, that more than 40 contracting states have signed up to, not yet the Russian Federation, but take this as an invitation. If we are pleased to help you on your path towards ratification of this convention. But there again, central authorities, quote, shall encourage amicable solutions with a view to obtaining voluntary payment of maintenance where suitable by use of mediation, conciliation, or similar processes. By including these provisions in these conventions, the members of the Hague Conference responded to the growing trend in finding amicable solutions often outside the court systems through, for example, mediation. This trend is based on the consideration that mediation or similar means of consensual dispute resolution are an effective means to achieve solutions that protect the rights of the child and to take into account the best interests of the child. Let me give you an example for when mediation effectively can protect a child's rights. Article 9.3 of the UN Convention on the Rights of the Child urges states parties to respect the right of the child who is separated from one or both parents to maintain personal relations and direct contact with both parents on a regular basis, except if it's contrary to the child's best interests. This right is of particular importance, of course, in the context of international child abduction, where one parent wrongfully removes the child from its country of habitual residence to another country and thus separates the child from the left-behind parent. As you know, the Committee of the Rights of the Child encourages states parties to the UN Convention to give effect to this particular obligation of Article 9.3 by ratifying or acceding to the 1980 Hague Child Abduction Convention. Contracting states to the Hague Child Abduction Convention have found that mediation can effectively support the application of this convention, since mediation facilitates an amicable agreement between the parties regarding the return of the child to its country of habitual residence, or an agreement that the child would not be returned, but in those instances, access rights for the left-behind parent are typically determined in the agreement. Mediated agreements on these matters reflect a tailor-made solution, which is in the best interest of both parents and which enable the child to maintain continuing contact with both parents. Let me focus on this for a moment. Although international child abduction cases are among the most emotional and complex family disputes, mediation has found its way into the consciousness of all stakeholders involved and is seen as a tool to find an effective solution which is in the best interest of the child. Mediation can first of all be used to prevent the wrongful removal of the child. For example, when the parents find an amicable agreement on the relocation of one parent with the child to another country by guaranteeing regular contact with the left-behind parent. So where a couple is on the verge of breaking up, but they still talk to each other, they go into mediation, and they do find an agreement that one parent may leave the country of habitual residence, settle back in his or her state of origin, typically, take the child with him or her, but also guaranteeing that the other parent continues to have regular contact with the child. Now, when a child abduction has occurred and an application for return has been filed, mediation between the parties may facilitate the prompt return of the child. It may also help to address some of the concerns of safe return or financial issues that the taking parent may face when returning with the child. In other words, mediation has the clear and obvious potential to make the return of the child to its country of habitual residence smoother, less painful, less emotional. As mentioned, mediation is also an option when the left-behind parent does not request that the child be returned, but instead that his or her access or contact rights are effectively protected. In these cases, mediation may help one parent to accept the relocation of the child with the other parent and in return focus on effective contact agreements. The effect on the child in these cases may be enormously positive. The child may avoid subsequent relocations which may occur if a court first orders the return of the child after an abduction, but in subsequent custody proceedings, another court in the state of habitual residence supports the lawful relocation of the child to another country. So the child is subject to constant moves back and forth from one country to another. The child would also be saved from a, unfortunately sometimes long, court procedure and from a possible further worsening or complete deterioration of the relationship between the parents over the course of this process, if effective mediation procedures are in place. Mediation may also be useful at the stage of enforcement, namely when the court has ordered the return of the child and gives parents the option to agree on how the return will take place. Finally, mediation is a useful mechanism in the custody proceedings that follow the return of a child. In general, mediation in child abduction cases can lead to more sustainable solutions since they are more likely to be adhered to by the parties. It also establishes a less conflictual framework for the return or relocation of the child and therefore contributes to limiting the emotional damage to the child from these situations. Undoubtedly, therefore, mediation is a means that contributes to finding solutions that are in the best interest of the child and help protect the child's rights. Now, in recent years, many states have actively embarked on a path to promote alternative dispute resolution in family matters and developed laws and policies to encourage, facilitate, and regulate, particularly the area of mediation. Mediation has become, in many states, the most promoted approach to settle family conflicts. In some countries, it has even become mandatory to try mediation in these cases before going to court. Most action by states in relation to mediation took place at the national level. But since the number of families with international, intercultural, or interreligious backgrounds has been increasing constantly over the years, mediation has become international and even global. There are, however, at least two challenges deriving from this globalization of mediation. First, mediation is not the same everywhere in the world. It is practiced and regulated in quite different ways. And even what we would call basic principles of mediation, such as voluntariness, confidentiality, impartiality, and fairness, are not applied in a uniform way. Secondly, cross-border family disputes can be extremely complex and may pose legal and practical challenges to the mediation process, such as different legal systems, different languages, different cultures, and geographical distance of the parties, which in turn may raise financial issues. One way to respond to these challenges is to provide more information about mediation in international family disputes. For example, the Hague Conference on Private International Law has published in 2012 the Guide to Good Practice on Mediation. The development of such a guide was seen as necessary since mediation in the context of the Hague Child Abduction Convention must take account of the particular legal framework of the instrument and must operate within a very contracted time frame. I'm very glad to say that a Russian version of this guide is available thanks to the Scientific and Methodological Center for Mediation and Law in Moscow. Another way to respond to these challenges is, of course, to train specialized mediators. States, non-governmental organizations, and private mediation or lawyers' associations have started to conduct such specialized training, although predominantly on a national basis, with a few exceptions, among which the European Union, that initiated a training for specialized mediators from member states of the European Union. All these efforts are important and necessary, but do they keep up with the growing use of mediation at the international level in often complex cases? Or should more be done, particularly by states that often promote mediation for various other reasons, such as to free up overburdened courts? The question, therefore, is how can mediation be further strengthened in international family disputes? Contracting states to the 1980 Hague Child Abduction Convention have noted the opportunities that mediation offers in these cases and have been actively incorporating mediation in Hague return processes. The scope for mediation, however, may be even larger in the framework of the more general 1996 Hague Child Protection Convention, whose main function is to prevent conflicts of jurisdiction relating to children, to resolve doubts about the law applicable to parental responsibility, and to provide for the recognition of protective measures for a child. The 1996 Convention may apply in highly controversial and emotional cases, including those involving the removal of children. Its scope, however, encompasses a whole host of cases on protective measures for which may be less or even non-controversial, and in which parents would even more likely go for mediation to settle the issues. Since the 1996 Convention also contemplates that measures of protection may be by mutual agreement of the parties, as opposed to judicial determination, it seems to be likely that international family mediation would play a very important role in cases falling within the scope of the 1996 Convention. The use of mediation in cross-border family disputes will therefore continue to grow, despite the challenges it may face. Although much has already been achieved, mediation in international family disputes needs our continued attention, in particular with a view to ensuring that it meets its objective to protect the best interests of children. These, Madam Chair, were some remarks, comments of a general nature. Thank you very much for your attention. I will, of course, be more than happy to take maybe some more specific questions to tell you in some more detail what we are doing in terms of very specific efforts to provide a framework for the smooth operation of mediation within our conventions. Thank you.
Thank you very much, Mr. Berlusconi. And of course, we do have questions that we would like to ask you about the efforts that are undertaken by the Hague Convention to broaden the application of mediation. But now I would suggest that we give the floor over to all the presented here speakers and then tackle the questions. Now I'd like to give the floor over to Mr. Jean Ayoub
Everybody. First of all, I would like to say that I'm very happy and grateful to be here in this wonderful city and to be able to participate with you in this very important topic. A couple of words on the International Social Service. It was founded in 1924, so this year we are celebrating 90 years of existence. Not too many international organizations survive 90 years today, and all those organizations who were founded in the 19th and the 20th century, very few remains in operations today, and we are particularly proud of that. The idea of the International Social Service was born to accompany migration routes from east to west and from south to north after the First World War, and slowly but surely it developed and adapted to new challenges in this world post the Second World War. And we became essentially very specialized in all activities pertaining to child protection and family reunification. Some of our activities do include tracing of origins. We used to do adoptions till late 80s, but we have stopped now. In most of our offices, we do practically pre- and post-adoption care. We do tracing of origins, as I said. We deal with non-accompanied minors. We do support to central authorities in countries of origin in shaping their services or revamping their services. It's on request. For that, we work closely with the Hague Convention, with the Hague Conference organization and other organizations like UNICEF. And of course, we do mediation, transnational mediation, international cross-border mediation. We have a lot of definitions and titles for it, and most of it converge to the same. Since our topic today is mediation, I would just like to say a few words of how ISS looks at mediation. Actually, again, as Mr. Bernasconi has said, at the end of the day, the best interest of the child is preserved, and we do tend to think about that in every single activity we do at an international organization. ISS today is present in 120 countries. It's a global network. It gives us access to all these countries. It gives us the ability to use the power of the network to enhance child protection and family reunification. For us, and to be very simple, just our organization has two legal bases since the 50s, to begin with the Convention on the Rights of the Child, and since the 80s, the Hague Conventions. These are our legal bases, and we work on those legal bases. For us, we have invented a simplified code to talk about mediation, because we believe mediation needs to be simplified so it's accessible to everybody. As Mr. Bernasconi has said, it is a must that mediation is considered more and more in conflict resolution, in international family dispute, child abductions, wrongful removal of children, and similar situations. For us, mediation does not replace justice or the rule of law. It just complements it and works along its boundaries. It is important to consider mediation as a voluntary action. Parents do go into mediation in most cases as a voluntary action, and they commit to make it work. Again, as we talked about that, it places or replaces or reminds parents that the best interest of the child within that process of mediation should be always kept above all other considerations. Another role that we focus on is that we look at mediation as a possibility to allow parents in a broken family to continue to assume their responsibilities as parents. When parents are together, they have these collective responsibilities, but when the family breaks apart, this responsibility becomes blurred. It becomes a little bit more difficult to assume. So mediation allows the parents to continue to have this role in parenting and shaping the future of their children. It is flexible, it has to remain flexible, and offers the possibility to tailor situations, to tailor solutions to different situations. As Mr. Bernasconi has touched upon it, and this is very important, it accommodates cultural differences and sometimes differences in practice in religions or something like that, and it can very well target binational families. parents of different origins. Last but not least, it is cost effective. It takes shorter time usually if parents are committed, and it saves a lot of trauma on the children who are and most of the time caught in family disputes. This is the way we look at mediation. We are proud to announce that in the next weeks we are going to produce the first manual on transnational or international family mediation, which targets parents, and this is our added value in the process of mediation, as I said in the beginning of my few words, is to simplify the process, to simplify the technique, to simplify the activity, and make it accessible to all parents in need. The manual will be published in the next 6 to 8 weeks. It's nearly there. We are on the editing phase. It has been compiled using the knowledge, the experience of many experts in the four corners of the world, and of course experts from the Hague Conference and other important organizations. So probably just to say that again, we're very pleased to be here, very grateful for the Minister of Justice and Minister of Education and Tsisana for the invitation, and willing to take on your questions and more clarifications later on. Thank you.
Thank you, John. Thank you very much. And as I said,
thank you very much. As I already said, we will take questions after we hear all the speakers. Therefore, I am happy to give the floor to the next speaker in my list, Alexey Astahov, Special Representative of the President for the Interests of the Child. Good morning, distinguished colleagues. In a traditional sense, mediation is a process that can involve an individual or a nation. Usually we think of mediation as arbitration, as engagement of a third party. No, it's true. Mediators are always in the process as the third party, and mediators as such must have special features. One of them being patience. Patience is key to any mediation procedures, especially in family relations. Without adequate patience, dealing in family affairs is almost impossible. Mediation is always a quest for a solution in a very difficult environment. In my opinion, in the family environment, a mediator must be also an educator. Any mediation outcome must promote the improvement of family relations, improvement of the internal climate in the family. I always was interested in mediating family conflicts and family disputes, and thank God I had a chance to have a first-hand experience in the United States. At that time, the pioneer of mediating procedure. I had an internship. I was not involved in family disputes, but rather commercial disputes. However, once appointed to my position that I occupy today, I found my internship exposure very interesting and fruitful in things that I'm doing now. This is a new front line in jurisdiction. In building this new branch of legal practice, we must first of all keep in mind the welfare of the child and of the family. We must do everything possible to save the family, to cure the internal wounds. The office of the Child Ombudsman in Russia is recently new, relatively new. Therefore, there's very little practical experience to draw upon. International experience could be a source of knowledge, but its applicability in the Russian landscape is pretty limited. Now, one of the challenges that we face is harvesting practical knowledge, knowledge of legal enforcement. Imagine an institution that is fledgling and yet doesn't know how to go about in this world. Is very difficult. Russian Federation has about 80,000 cases of withdrawal of parental rights. It is a huge number. Therefore, the field of practical application of mediation procedures is enormous. The number of parents actually with their parental rights retrieved is 40,000. Again, a huge number for a country like ours. And the number is growing every year. Why did I decide to raise this particular issue? The process of withdrawal of parental rights is the apex of a family conflict. The outcome means that the family no longer can exist as a social unit. The family is broken. Mediation procedures probably would offer a chance to save the family, to save family ties and the family contacts. Every year we are marking another record number of successful outcomes through the use of our mediation procedure. It is a fact that in bureaucratic terms it is much more easier to withdraw parental rights, and that's it, period. Mediation is tedious, it requires patience, and patience is a commodity in deficit. No need for education or anything like that. I'm proud to tell you that we have been successful in changing the mentality and attitude. The Institute of Mediation is gaining ground in bureaucracy, in the public sphere, in the legal system. Mediation is addressing at the same time the child and every parent. Previously, I thought of mediation as an exercise in developing a compromise, a consensus, or drawing up rules of coexistence, either between spouses that may have conflicting interests or conflicting rights in terms of property or childcare. But very soon I found out that mediation is not limited to this sphere. Mediation can be applied to situations of legal relationship of a child and the state, child and the parents, parents and the state, and all of them with the state. Child ombudsman is often a mediator between the state and a family concerned. between parents and the child. Four years of operations that we have on record have shown that we are capable of applying mediation procedures with a good number of for a good number of families. Every year we're scoring an addition of several percent of successful outcomes. During this time, along with the growth of the mediation institution and all organizational and accountability structure that there is, we're gaining ground in other respects. Practically in every federal region, we have opened a mediation center. Last year we had 30 such centers. Now we have 60 mediative centers. It is my opinion that every major city and even a moderate city ought to have such a family assistance center, call it whatever you like. Such centers would have a mediator on its staff with the primary task of preventing family conflicts from escalating to the point of breakdown. Now, this is a brochure in my hand from the Mediation Center of Astrakhanskaya Oblast. It tells you all. It is for free public distribution, for public awareness of the existence of this mediation center. Mediation must be a very open institution, easily accessible to masses of population. The experience proved very successful because now we have seen the growth of a number of activists that are pushing this idea in the field. Some 3 years ago, we used to have a very difficult problem, a very difficult trend, the growth of child suicide. Now, having registered this worrying trend, we thought about doing something about it. What we did was to establish mediative and consultative services in public schools. This new institution was meant to replace the old staff position of psychiatrists. Schools that do not have a psychologist on its staff eagerly accepted to have a mediator. Such a person is needed to have an eye over kids with problems, over kids that feel ostracized from the school community, from the families. The task of a mediator is to investigate such cases and probably to find out the child's family background. This measure bore fruit in terms of decrease in the number of child suicides by 100%. All of this bespeaks of huge potential that there's out there in the sphere of mediation. Conflicts ought to be suppressed in the very beginning, very early on, especially when the child is involved. Bad family environment is the breeding ground for future troubles with a person when he grows up. This is a very tedious work requiring patience, requiring enthusiasm, requiring active social position and awareness. We need such people and we need such an institution, and that institution would need a special law. A law should be an instrument to help cure an ill family, to help a family heal its wounds and probably survive as a social institution. So the bottom line is we will be harvesting our own experience, our own good practices. We cannot expect foreign good practices to take root 100%. We cannot accept the situation when the government takes on the full responsibility over child care, which is the case in Europe, in France and in Finland and so many other European countries. We want to be different in this respect. And one more number that I'd like to quote. In the sphere of family relations, there's so many disputes along the road. Disputes between spouses and children, and between children. There are natural children and there are adopted children. So these are two categories could be potentially a source of conflict in the child environment, among the children. We are engaged in an analytical exercise of finding methods to save or improve the family climate with the children of different origin. We are thinking about creating a special service that would work with families with adopted children. Last year we have seen a record number of adoptions in the Russian Federation. However, the number of children returned to a child care institution has also grown. Well, skeptics have justifiably pointed out this trend to us, which means that we have to work with families that chose to adopt children. Such families need a special approach. A good number of children in custody of the state come from relatives or close friends, probably a grandfather, a grandmother, an aunt. Initially, those people thought that it would be helpful. However, neither materially nor psychologically, such usually elderly people are capable of fostering a child. The only outcome is surrendering the child to a foster institution. Therefore, again, as I said, we need mechanisms to assist foster families and to assist child care with relatives in case of death or disappearance of natural parents. We know for a fact that after initial period of euphoria, after the adoption of a child, comes a period of frustration. This is a very natural flow of emotions, and that's when our intervention is needed most. At this point in time, we have to step in and help that family save its environment, help the child stay in the foster family. Now, a special situation is adoption of children involving foreign nationals. They may not be numerous, but they are especially difficult to resolve. We have very limited possibilities to intervene or to assist our adopted children in a foreign country, like Igor Savelyev, who was simply brutally kicked out of the family, put on a plane and sent back to Russia. And he was a third child that was adopted by that mother. Recently, we have had another case of a return of a child from the United States from foster parents. Foster families thought that after coming of age, they no longer need him and he can go back. That's what he did. For a period of time, he was homeless, he was jobless. He was a real problem. His only occupation was washing cars, you know, some homeless state of life. We had to intervene to help this child. American parents refused to take him back. We have to deal with him right here. Now, honest mediation involves hearing both parties, or rather all parties involved. Therefore, it was our duty to reach out to foster family and ask their opinion. In case of a negative outcome, we have to have a recourse to the American court for compensation. That's what we are going to do right now in this case. So therefore, as you can see, our job is very interesting and very challenging at the same time. It is my opinion that mediation is the way of the future for a civilized resolution of family affairs. I'm a lawyer, practitioner. Society used to find recourse in courts. That is not a very a good idea. We don't need to resolve our cases in courts. We have to find solutions ourselves, and that's what mediation is for. We must seek peace in family relations. Therefore, it is the way of the future. Thank you for your attention. Thank you, sir, for your very inspiring and very interesting presentation. Indeed, we are good at suing each other. 20 million court cases are heard every year. This means that every fifth members of our society is going to court every year. I believe that mediation may be the answer. It is a very humane way of protecting individual rights without recourse to public hearings, without conflict, without spilling blood. It is a way of peace and family welfare. It is a very benign procedure, especially when a child and parents are concerned. Here I would like to quote one of the fathers of mediation in Russia. Now, we have heard here someone saying that in some countries mediation is mandatory, and Great Britain is one of those countries. So the quote sounded like this: even if we stop being spouses, we cannot cease to be parents. I hope that people, when marrying each other, would think about the future when they will bear children and become parents. Therefore, education, information, raising awareness about parental responsibilities is a big element in mediation. First, I have a question to Mr. Bernasconi. I would like to know, the Hague Conference, does it make any additional effort to improve the practice or expand the practice of mediation involving family affairs, involving transboundary family affairs?
Thank you, Madam Chair, for this a very pertinent question. The short answer is yes, yes indeed. You have to understand that the Hague Conference on Private and National Law, all we do always has a cross-border element. Now, so we are talking about a situation where you have a mediated agreement that was reached in one country. Now you want this agreement to be enforced, if you wish, for lack of a better word, but to make it legally binding in another state. That, of course, adds one layer of challengers, if I may say so, to the mediation process as such. With a view to addressing these challenges, first to analyze, understand, and address these challenges, we have put together an experts group, an international experts group that is looking into this particular question. How can you ensure that your mediated agreement, which you reached in one country, is legally binding in another country? The model we are exploring is in particular the model where the mediated agreement would deal with a series of questions. A situation where parents, for example, want to address the question of custody. The parents want to address the access right of the parent who would stay in the other state. They would like to address financial questions, such as the maintenance obligations. They may want to take other measures in relation to the education of the child, what have you. What we're talking about is the so-called package agreement, the mediated package agreement. And you would like to have that agreement as such recognized or rendered legally binding in another state. That raises all sorts of technical private and national law issues, because the receiving state, the recognizing state, will want to make sure that the state of origin really had jurisdiction to hear these matters. There might be questions of the applicable law and what have you. What you want to avoid is a situation where the package deal has to be split up, and then you have to go to different institutions and different courts, possibly, to have the agreement recognized in the other state. So what we try to achieve is a situation where, in the state of origin, the parents go to one authority to mediate the package, and then the package as such is being rendered legally binding in another state. All of this discussion, however, takes place against the background of the existing instruments that are on the table already. There is no need in reinventing the wheel where it's not necessary. And one of the most important instruments we have out there to possibly have these mediated agreements recognized is, of course, the 1996 Child Protection Convention, which has a very broad definition of measures taken in one state which are to be recognized in another state. So what I have asked this group to do now, this experts group, is, with the support of the Council, of course, of the Council on General Affairs and Policy, of all the members of the organization, is to really answer the question as to what are the practical challenges and difficulties with the recognition of these mediated agreements in the state of destination, if I may say so, and to what extent would these challenges and difficulties not be covered already by existing instruments, including in particular the 1996 Convention. And only if we come to the conclusion that yes, there is a practical challenge in having these package deals recognized abroad, and yes, if the conclusion is that the existing instruments do not fill all the gaps, then will this experts group develop a solution which can be either a soft law solution or a hard law solution. It could be a guide to good practice on the how to render mediated agreements legally binding in other states, a guideline type of document. Or it could also be that we would then ask this experts group to possibly prepare the negotiation of a binding instrument, a hard law instrument, on the recognition of mediated agreements. I'm saying here mediated agreements because that's the title of our panel, but in fact the mandate of the group is actually a bit broader, because it would not only deal with mediated agreements, but indeed with any form of voluntary agreements. That is work in process. That is work in the pipeline. The group met once. The group will meet again in the course of next year, because our pipeline is so full and our staff is so limited that we cannot do all these things at the same time. But I would say stay tuned, and maybe at next year's forum there will be more specific news already about the outcome of this particular process, but which indeed is a very important process we have running right now at the conference.
Спасибо большое. И действительно, исполняемость решений, признание решений – это, наверное, очень важный вопрос для всех. И вообще очень много правовых вопросов, которые возникают. Буквально недавно была конференция, на которой и господин Бернаскони, в которой участвовал, собравшая в Гааге юристов, медиаторов, и обсуждались вот эти самые злободневные вопросы, которые беспокоят. И нам вот только, можно сказать, получив новый закон, позволяющий имплементировать конвенции, у нас впереди еще много. Не только у медиации и у Федерального института медиации, а очень много таких дел, которые необходимо сделать для того, чтобы этот механизм заработал. Я обращаюсь к аудитории. Есть ли вопросы? Коля, Николай. Нет, до этого самого перевода.
Dear colleagues, I would like to introduce myself. I'm chairman of the Belarusian bar, and I'm a mediator as well. I have a proposal and a question for family mediation situations. You would agree that all the states are interested in preventing ruination of families and keeping families, but the state does help to ruin families, even technically, because there's a court's decision, the court rules divorce decision. Of course, attorneys also help to do that, especially if this has to do with the child bringing up or just property division. It is very seldom, if ever, happens without the attorneys and legal help. Is it really profitable and beneficial for a lawyer who is involved in mediation to keep up the family, both materially and otherwise? So the legal profession member, of course, should be interested in keeping up the family. On the other hand, he, by doing mediation, loses a client. However, he could have spent the next year making a lot of money on helping people to distribute their properties and do other things related to such cases. So we should either approach it at the legislative level so that the divorce procedure, for example, should not happen without mediation processes involved. Or another proposal, the state that is interested in keeping up the family should pay up a compensation to the lawyer who succeeded in keeping the family through the mediation procedure. Thank you, colleague, for your question. I just remembered a wonderful joke when a lawyer comes to his father, also a lawyer. He says, "I finalized the Menshikov case, which you have been resolving for 30 years. Oh, my goodness, son, you're an idiot. This is what we're fed on for the whole of our lives." Again, here it is very difficult for a legal profession member to kind of step on his throat, so to speak, but we have to think of the humanitarian values above the material values. And you took the words out of my mind, really, that the proposal you made about the kind of a pretrial regulation is an important way. We still have a legal provision that the people who want to divorce need to spend some time thinking about their decision, and this time should be used for mediation. We have accumulated interesting experience here in Russia in particular. And I would like to draw your attention, dear colleagues, to the judicial practice. It's not a mediation practice purely. It's not even, we have councils and commissions. We have wide-ranging religious confessions, both Orthodox, Muslim, and others who have this experience. For example, in Chechnya, council that is responsible for family dispute regulations, this conciliation procedure proved very efficient. It is not a mandatory request. However, those who go to court for divorce, these people are automatically referred to the mufti, to the kind of council, and in 90% of cases, people change their decision. So, of course, I think it is a worthwhile effort to initiate this amendment. We also have all the necessary legal acts in place on mediation and tertiary judge, so we can use them in this quite sensitive sphere. Yes, I think this is an important issue indeed, but it is a very entangled and complex one at the same time, because it is inclusive of many different aspects. Now we're preparing, and you, Pavel, are very important contributor to the development of the concept of family policy of the Russian Federation. And discussing this issue should have been a very timely exercise, of course, because this family concept, a basic concept, will help further turn these ideas to practical instruments. And of course, the instruments and cannot be very simple, because the situations are complex by definition. So mediation, whether it should be a free or a process that should be paid for. I think if the state has to provide for this process, the state has to create it as a new resource, but not as a new market. Of course, I thank you, our Belarusian colleague, for raising this important issue, and I think this is an important discussion theme as well.
Thank you very much, Madam Chair. I thought this might be a good moment to introduce what the Dutch refer to as the pressure cooker method. I hope this comes across adequately with the interpretation. I would preface my comment by first saying that I wholeheartedly agree with what has been said by my colleague Jean Ayoub from the ISS, that mediation should not be seen as a substitute for judicial proceedings, but rather as a complement to judicial proceedings. And that is exactly what the Dutch have done now in a very effective and efficient way, I tend to believe, in the context of child abduction matters. I do realize that the question was about divorce, but very often these questions all come together and need to be addressed in the same procedure. And so what the Dutch have done is, within the framework of the Hague Child Abduction Convention, which, as you probably know, sets a goal. It's not really a strict rule, but it's a goal of a 6-week procedure. Within 6 weeks, ideally, you, as a court, issue a decision as to the return, or possibly the non-return, but typically the return of the child to the state of his or her habitual residence. What the Dutch have done is they have sort of put together the judicial proceeding with the mediation procedure. What happens is that, and all of that within 6 weeks, what happens is that there is typically a pre-trial review where the judge meets with the parties, typically within 2 weeks after the filing of the application for a return. And very early in the process, the judge would refer to the possibility of mediation. That cross-border mediation would then take place. Typically, it involves a psychologist mediator and a lawyer mediator. And they meet with the parents for 3 days, hence the name of the pressure cooker model, because all of that is very condensed in the overall 6-week procedure that within which the Hague application has to be or should be dealt with. They meet on 2 to 4 consecutive days, including a Saturday, by the way. During this time, the parties always have the possibility to consult with any other experts they wish, with other family members. They can continue to talk to each other. There are moments where they are in bilateral talks with the mediator. There are moments where all the parties are together with the mediators. And then, after the mediation process, there is the full hearing by the court, which then issues a decision, which can be a purely judicial decision if the mediation failed, or it can be the judicial sort of endorsement of the mediated agreement reached by the parties. The interesting thing is that nowadays, with this model, which started in The Hague, for the time being, I think it's only in The Hague that it works, and it started in January 2012. It is used in 65 to 70% of the cases where this mediation mechanism, the pressure cooker model, is used, and from what we know, to the greatest satisfaction of all involved, not just the parents, but indeed also the mediators, obviously, and the judges, because their job is also made easier if it's effectively accompanied by good mediated procedures. Thank you.
Спасибо большое.
Thank you very much. And indeed, this is quite a telling example that we just heard, which demonstrates that mediation, when carried out in the process of the Hague Convention implementation, is a little bit different, like Mr. Bernasconi said, in that it is a very condensed one. Hence, in the framework of the kind of a state order, we're creating an international task force that includes international mediators, experts, and it's a very good pretext to announce this here for this audience, because among the participants here there are people who have who are fluent at least in one foreign language and have either legal background or psychological or social sciences background. Hence, we would be happy to consider the candidates, because it's exactly now that we're recruiting the task force, the team of international mediators. I could refer to the Ministry of Education website that has detailed information about this initiative. Now I suggest to take questions from the floor, if any. Please. Thank you. Could you please introduce yourself? St. Petersburg State University, the Civil Law Department, School of Civil Law, and as we have a concept that we have to review the concept of reforming family legislation. Our chair is reviewing it currently. We have two major areas, foci that cut through the concept, and these two areas, I think, quite questionable. And picking up on the proposal that our Belarusian colleague made, the first area is requesting to very strictly define traditional family values in the family legislation, which I personally don't think is feasible. And taking advantage of Mr. Astachov's presence here, maybe it does not relate to mediation issues directly, but family law more. I would like to have your opinion on that, because they insist that the family legislation at this point in time is not possible to implement without the strict definition of traditional family values. I don't think anyone has any idea of what traditional family values are all about at this stage, and it is now, I think, very dangerous to spell them out in such detail in this family legislation. And the second procedure is the just mandatory mediation in all the family disputes. We have a lot of divorce rate is extremely high in this country, and of course many of the marriages could have been maintained and kept afloat. However, now you mentioned that they will face challenges, but I don't think I understand how we can omit to say anything about this in this concept. We have to review this and provide an opinion, and we need to review the mechanism of mediation. We don't have specialized courts in the Russian Federation, and the divorce cases are reviewed and ruled on by the court that it was applied to. Sometimes the judges are even younger than the spouses that want a divorce and does not know many things about life as well. If we introduce the kind of the paid mediation, that some of the spouses will not be able to afford it materially, financially, and sometimes we talk about several sessions that are aimed at conciliation, and then it will be an unaffordable burden. If it's a free procedure, it has to be supported and introduced by the state. I know that I don't think that the Ministry of Finance will be very happy to hear this proposal for amendment, because it is going to be an additional financial burden. It has to be, as far as I understand, taking it through the Duma. It also needs approval from the financial ministry, and I don't think this mechanism of free mediation, state-sponsored mediation, is feasible, because top-notch expert services are very expensive, and it gets into a risk of becoming just an extremely very formal procedure, and it's not very good, just to draw the analogy in the face of our foreign colleagues, meaning that it's as if you were referring people to get medical services not in a good commercial clinic, but in the district-based out clinic, and it's going to be just the situation when people will queue up for hours to get an informal consultation rather than an efficient mediation process. So I would like your opinion on incorporating mediation process in the family legislation development. Thank you very much for raising this topic. I'm very much concerned about it personally because I'm also participating in the concept discussions and disputes. Indeed, it triggers off a lot of differences in opinions, a lot of argument. However, I was surprised to hear from such a young and good-looking lady from St. Petersburg and a lawyer into the bugging such pessimistic view on the situation, because it is not a very usual thing for St. Petersburg community. However, seriously, my opinion does not always coincide with the concept developer's opinion. Any legislation, I think, works efficiently and effectively if it codifies some of the public practices that the society has endorsed upon. And if something is not ripe yet to an extent to be codified, we need to treat it with caution. Because we need to be proactive. However, we need to identify the major development factor, but also allow for some variance. Of course, values, and any society has to have values, as family values including, but family values in different parts of our country may be viewed and interpreted in a very different way, depending on the religious confession and cultural tradition, others. And we are a vast country. And if we want to set one thing for all, it is quite a dangerous thing. And I think this process has to be mitigated. However, we need to discuss these issues. We cannot abstain from it. And if they are not mentioned in such official high-status documents, we wouldn't have the further opportunity to finalize and develop them. As to the financial aspect, Pavel Astachov, and I agree with what he said, it has been quite visible progress that the society's views on the children and children's problem are evolving and changing. So if a state withdraws a family from a child from a family because it's dangerous for him or her to be there, it is not viewed as an effective mechanism, but as a last resort measure rather, that the state needs to take, because all other state-supported institutions did not act effectively to maintain this family, to prevent it from ruination. And when a person gets into the state custody, if we speak financial language, this child costs much more to the state than a child who is still living with a family. So it's another argument for financial community, especially minors. For example, minors have to be isolated, put into just legal custody. It's a very low effective and just forced act. So when the state finds there is the financial and other resources to back up this process, we successfully resolved the preschool education institution problem, though it looked unsurmountable. However, we need to resolve this situation in all the regions by 2030. We have introduced over 250,000 various units across the regions. and the state found adequate financial resources to maintain this new network. But you raise also some legal issues about this proposal. And of course, you need to state it, you need to substantiate it, and you need to mention it in your expert review, because not a single order issued by our ministry cannot be issued without a public hearing, without it being reviewed and studied in depth by the expert community, and it also has to undergo the web hearing where any citizen of the country can share his viewpoint. We need also to use this resource to harmonize this very sophisticated issues.
May I? Just a couple of words. Thank you very much for your question, and thank you for being so compassionate. I fully share your emotions and concerns. I just wanted to make a comment about why it is that we started discussing family values and the necessity to just design it. So from the very first day of designing this concept, I was largely supportive of it, because without the text of the conception, it is very difficult to understand where the society is bound for, because we always want to have some horizons and to see the perspective without, but not just solving everyday routine problems step by step. We need a far horizon as well, and the vision. As for the laws, and I would disagree with Demonstraevich, with Mr. Deputy Minister, again tackling the question about why it is that we are discussing it now. Only 2,500 years have passed since the Roman law, and the definition was given by Bondestinus of the marriage as a voluntary union of a man and a woman. And it is only now that we have started reviewing this definition. So we have some norms stipulated in our family code that marriage is between man and woman. I don't think that it can be reviewed, but there is only one reason to that. I'm absolutely not against different kinds of relations. In the Roman Empire, they did have other types of relationship, but they never substituted marriage with other types of sexual relationship. So this substitution would entail a lot of other changes in the law concerning the inheritance and so on and so forth. And then what about the family, the childless families? Again, in ancient Rome, Gaius, Justinius, and Justinian, they also just introduced this element into their definitions. So looking backwards into the history of the humanity, these are the issues that can be raised. But as for classification, type, and so on of families, I partially disagree with Vladimir Saevich. It's hardly likely that our understanding of the traditional family values is different in the Kamchatka or Caucasus or whatever. So probably just in the Caucasus they have firmer values than in Moscow and St. Petersburg in certain aspects. So yes, there are some core values that are uniform, but going in depth into detailization of those values would not be a wise step to make. So again, this is the issue of the borderline. We do have a problem that needs thorough thought and discussion. We really shouldn't haste about adopting this kind of document. So we really mustn't just produce some code that then would be criticized prematurely. So let's not hurry. If we do feel that there is a need in this society and that it should be and it should entail some changes in the legislation. Yes, of course, let's do that. Of course, the quickest response to the needs of the society was the lynch court and Ku Klux Klan, but we don't want to bring it to that extreme, do we? I do think that even if we do not write put those family values in writing, we will cease having them. They will still be pursued. Thank you. May I add a comment? The Notary Chamber of St. Petersburg. My name is Olga, and my question is about this legislative initiative and the comment by the previous speaker. In our everyday routine work, we confront the issue of family values every day when just writing a marriage contract, when performing some other notary actions. I do realize how important and useful it would be to have them in writing. And indeed, there is some positive experience of French colleagues because it's mandated for them to have some training in mediation. And mediation is really a very well felt need. So please think about that, about just introducing an element of mediation training into the education of notaries. Yes, indeed, I agree. If we start tackling this theme, then we should go further and implement programs for the upgrading of the qualification of specialists and special training of mediators. Maybe specializing in law or specializing in pedagogy, or maybe it should be something in between law and pedagogy. But this is the issue that we have been thinking about. And you have something to add, don't you? It is very important that our colleague from the notaries associate community already has this need to have the skills of mediation and has gone through training in mediation. And she does realize the importance of this skill and practice. And the Russian legislation gives ambiguous interpretation about whether notaries can use mediation in their professional activities and how, and whether they can act as mediators in the resolution of disputes. But I do agree with what you have said, and I realize that you probably started facing this problem. As for the French experience, even ombudsmen just had the name of Mediator till recently. But as for using mediation in notary practice, yes, in France they indeed try to use their mediation skills. They do not act as full-fledged mediators, but they do use the skills. So the more notaries who are at the same time trained mediators we have, the better. The broader will be the use of this practice. I have a question to Mr. Ayub, my colleague. When he spoke, he clearly outlined the challenges concerning the transborder conflicts and disputes and so on. And indeed, it is of our greatest concern nowadays. In the very beginning, I mentioned that I have come here from Krasnodar, where we are having this Russian national conference on the problems of related with that. And we do have the whole range of new issues for us. The issues related with the children who come from our brotherly state of Ukraine. And there is a huge inflow of children, and the origin of those inflows are different. There are kids who come with their parents, and then it's more than less clear. Then there are some other children who come without their parents on the letter of trust. Others just run away from war, and this makes the situation extremely complicated. And I think that international experience of mediation in those painful issues could be very helpful for us. Because, well, fortunately, I must say, we have never had this experience before, but now it's high time to start acquiring it. But we want each and every child who comes onto the territory of Russia to be protected and fed and provided shelter with. But at the same time, we envisage or anticipate the problems with their parents in this or that way. So is your organization interested in rendering consultancy aid to us in those issues, sharing international experience?
Thank you for the question, and yes, the short answer is definitely yes. We can share our experiences, and we can learn from different situations. Of course, non-accompanied minors, families in general, displaced by internal strife or international wars, they do have a special category. They are called refugees, and they are governed by international laws, refugee laws, and things like that. But then again, on a case-by-case basis, essentially in non-accompanied minor cases, we need to study the case, again, individually, why this minor has moved. Is it for security reasons? Is it for economical reasons? What is the best interest of the child? Is it to stay away from the family? Is it to be reunited with the family? What are the conditions of return? And return for minors, according to international legislation, should be voluntary. Can it be forced return? And this, again, this is a study of individual cases, the conditions of migration, the conditions of return, and the safety and the best interest of the child. So definitely the answer is yes. I would like to seize the opportunity again to come on the different interesting discussions that were taking part in the last 20 minutes or so. And starting by the question and the remark from our colleague in Belarus, definitely there are lawyers who feed on dislocating families. But then again, I believe that mediation, and I heard that being said around the panel this morning, that mediation is the future. Mediation, there's a need for mediation. There's a need to understand what is mediation. And when people, as I said in my earlier remarks, go voluntary, parents go voluntary into a mediation process, that does not mean that once we replace the rule of law by the mediation, but that does not mean neither that they will not need any form of legal support. And this is why in the practice of mediation, sometimes, yes, it is the parents alone with the mediator that will have to forge an agreement. When this agreement is being reached, it has to be, let me put it this way, certified. It has to be legalized. And this is where legal counsel is very important. And I think more and more we agree that mediation is a need today in our modern society, and it will be more and more in a globalized world where people marry from different nationalities, retain the marriage or break the marriage, and we end up with binational families with children torn apart. Everybody should not only know a little bit about mediation, but everybody should, including the legal counsels and legal officers, should be trained to assume a better, more constructive role, because everybody has a role in mediation. Thank you.
Thank you very much for your answer and for the readiness to help us in this very painful issue. And of course, the best interests of any child is the first and foremost thing. This is what this country really propagates, and we hope that other countries will advocate this too in the future. I think that we will have separate discussion on this issue But now I would like to ask you if there are any other questions. And I can see 2 hands rising. Is it 2 questions or what? Okay, three questions. 3 questions, and then we will start bringing all this to closure. Okay, so I'm the representative of the Court on Human Rights. Unfortunately, we already have some resolutions of EU Court which violate the convention, and in those resolutions they say that our government violates the rights of the parents when one of the parents removes the child and prohibits the other parent to have any contacts with this child. And after that, EU, and we have this on the case Pakhomova against the government of Russia, the verdict is that the child must be returned somehow. We can't find the father. We can't find one father who is just hiding till now, however hard we try. So can we use any procedural mediation in this case, or would it have some negative impact on the child if the child is forcefully brought back to the mother, whom he doesn't remember anymore after 5 or 6 years? I can tackle the last part of this question, whether mediation is applicable here. So may I give you an example here about the Russian-French Commission that was established more than a year ago for the sake of really investigating the cases that do not fall within the prerogative of the Hague Conventions. And we have studied more than 14 cases. In 9 cases, we recommended mediation. So this work is being actively pursued. We also now know that we don't even have the right addresses of those parents of the other part. And very often this is the main obstacle in this type of work. And with those ones that we find and establish contact, they are highly aggressive, and they're against that because both parties are tired by those bureaucratic procedures. But finally we managed to win their interest over mediation. Currently we're tackling several cases that are rather old, and of course it's a pity when years pass and the parents, or one of the parents, has no opportunities to maintain quality contact with the child. And very often the children are already teenagers. And then we have another obstacle, that being that the child is no longer willing or ready to just interact with parents. Yes, each specific case must be investigated into, but what's general? People change, we all change, and changes are not always for the worst. So sometimes the views and the attitudes of parents change. Sometimes under the influence of the growing child. So it makes sense trying. The more we try, the higher the percentage of success. I know there are more questions out there, please. I'm Anna Tarasova from Rostov-on-Don. So my question is about the implementation mechanisms for mediation. So is it possible to implement mediation without having special staff in courts, people who would specify in different areas of law, protection of children, teenagers, and all that? In our case, we do not have specialized staff, and usually it takes a long time for each case. And we had to introduce certain mandated measures and even think about where to keep the child while the dispute between the parents is going on. So the Dutch experience quoted here before doesn't work, because if the court procedure is not successful, then probably, well, we must overcome those risks sometime. If we are thinking about this full-fledged mediation mechanism, can we really implement that without having special kind of support from the court? And then even the parents, they abuse some of the contradictions between the national laws, international laws, and so on. My colleagues may correct me, but it seems to me that in practice, there are many people who represent the trustees, the commissions on children, even without knowing that what they're doing is mediation, they really mediate, because our main goal is to kind of maintain, keep the family. And other things are extreme measures. And this is an existing practice that has been in place for quite a long while. Another thing that it should be more professional, with the involvement of psychologists and some other professionals. And so in my view, that just the answer to the question is yes, it should be like that. But then the institutes of mediation should evolve and develop just in accordance with the norms and principles of the conventions. And then those institutes will win more trust, and then they will have more powers. And maybe time will come that even without the intervention of the court, we'll be able to resolve disputes. Just if you remember, it was not so long ago that when the tertiary courts have been introduced. And so actually the situation is being changed. Okay, the very last question, please. I can see this female hand. For some reason, it's predominantly women who ask questions. Maybe they are the... I'm from the Urals, from the Law Academy, from Ekaterinburg. In your view, what is preferable and more efficient? Just involvement of mediators in the broad sense of the word, so the institutions and the trustees, the family centers, the ombudsman on their children's rights, or just mediators following law 193, and what proportion or correlation is preferable? Thank you for your question. You know, now we've been actively working with the Department of Social Protection in Moscow, and we use a combination of mediation. We have mediators. We have trained, first and foremost, the employees from the social services, social security services, but at the same time, sometimes they invite professional mediators with psychological education. So we can't really say that only one way is right. I think that a reasonable combination of the two is preferable. But what is really desirable is for the people to understand in which case which combination is more efficient. But for that, they need the deeper understanding of the procedure of mediation, of what it is. So again, a combination of the two approaches is highly preferable. And this is proven by life experience. Thank you. So we'll be bringing this to closure. And I can't say no to a woman. A very brief question, please. Now it will be the very last final question. So I'm Ivanova Ksenia from the Ivanov and Partners law firm in St. Petersburg. And my question is as follows. Just the citizens use their procedural rights, and if they have, they usually just have representatives in court. Is representation possible in mediation? And in case parents do not want to interact, how can we force them or just engage them in that? Because sometimes even when the courts mandate some parent to come to a court procedure, they wouldn't turn up to participate in the discussion. How can it be in case of mediation? Well, You are asking a question about whether it is possible to have mediation between representatives. Unfortunately, very often it's a necessity, because without it, it's impossible to break the ice that we very often see in those situations. And of course, it's a multifaceted question. It's the issue of professional ethics of those representatives. Contemporary lawyer must be able to give a clear-cut and understandable explanation about why it is that mediation is preferable, and why it is that it is recommendable for them to participate in the procedure of mediation. So indeed, where mediation is held, it's highly undesirable to have it only between representatives. But the practice is that at first we just have mediation between representatives. We persuade them to explain their clients' other issues. Sometimes we do it together. Then when parents have or when representatives have clear understanding, then together with them we can explain it to the parties engaged, and then they can make their voluntary choice. And this is the only way. Then may I just say some closing words. I'd like to thank the audience for the interest displayed and attention given. I hope this has been useful for you. It has been useful for us, of course. I'd like to thank the speakers, my co-moderator, Veniamin Kaganov, and also I want to assure you that now we're actively working for the sake of implementing 2 items of the national strategy on protecting children's rights. It's just setting up mediation services in educational institutes, and also developing the network of mediation in some other practices in this country. This will prove helpful in kind of really implementing mediation into family dispute resolutions and in protecting children's rights. I'd like just to join the words of gratitude expressed by Tsisana Shamlikashvili, and I realized that you had a choice between the panels. So if you are sitting here, that means that the issues discussed are the issues of your concern, and we will readily continue our dialogues. I do realize that you couldn't really ask all the questions boggling your minds, but we are already standing on the way to answering them. The institute headed by Tsisana Shamlikashvili is the only specialized one on mediation. So I would like to encourage you using the tools that are suggested by that institution. Do send in your questions, and the ideas and tools of mediation must develop. It is within our best interests. So separate thanks to Pavel Alexeyevich. We do not have any contradictions about the family values, about one-sex marriages or just bisexual families and all that. Of course not. Relations between us is an ongoing dialogue. And the only concern that we have is just providing timely, adequate solutions to the society. And jointly with our colleagues, we're moving ahead in that. We'd like to thank our foreign colleagues representing very highly respectable international organizations. We hope that our interaction will not end by this conference. Hopefully we'll continue cooperation. It is very important for us to get a clearer, better and deeper understanding of foreign experience and learn how to use it to protect the interests of our children, our citizens, in interacting with representatives of other countries and international communities. I'm ready also to share. In Russia, it's like this. For any cause to develop successfully, you must find someone interested, committed. It's very good if it is a woman. Give her some power and then let her work without making hindrances. And then you should join her in her success achieved. So as you see, this is what we are doing in this country, and I think that we succeed. Okay, all the best to you and have a fruitful time in this wonderful city.